You're watching the Legal Breakdown, and today, we have a seismic shift in the legal and political landscape that you need to understand. For months, we've seen Donald Trump try to flex his executive muscle in cities like Portland, Los Angeles, and Chicago, deploying the National Guard as a show of force. A move that's raised alarm bells for both constitutional scholars and ordinary citizens concerned about presidential overreach. Initially, every legal challenge to this strategy resulted in the same kind of judicial speed bump, a temporary restraining order, maybe a preliminary injunction, but nothing that fundamentally changed the rules of the game. Everything until now has been about buying time, stalling Trump's troop deployments until the courts could sort out whether they were legal or not. But for the very first time, we aren't talking about temporary blocks anymore. We've crossed a threshold. Now we have a final ruling on the merits, and it says, in no uncertain terms, Donald Trump broke the law. Let's talk about what really happened. Federal District Judge Karen Immergut, who was appointed by Trump himself, did what so many other judges hadn't yet been able to do. She held a full 3-day trial, bringing in law enforcement from all sides, federal, state, and local. She reviewed an enormous stack of documents, heard testimonies from every relevant angle, and finally ruled decisively. This wasn't a technicality, or a debate over legal procedure, she ruled on the substance. She found, after all the evidence, that Donald Trump violated 10 U.S. Section 12406, and just as importantly, the 10th Amendment to the U.S. Constitution. In plain language, Judge Immergut permanently barred Trump from deploying the National Guard in the streets of Portland, or anywhere else in the state of Oregon, unless there's a reversal on appeal. This is not a move that will expire in 30 days or get lifted with some new emergency. This is a wall that stands up as long as the case is alive, unless the Supreme Court intervenes. Let's dwell on what's new here. For months, the legal playbook for challenging Trump's moves has been delay and hope. Temporary restraining orders stop federal troops from marching in, but they don't settle the question: can a president order the National Guard into U.S. cities over the state's objections if there's no insurrection, no invasion, no inability of local authorities to handle their own affairs? Previous lower court decisions merely kicked the can down the road. They provided a pause, but not an answer. Today, that answer has come, and it is powerful. Judge Immergut didn't just declare Trump's actions unlawful, she called them unconstitutional, saying he crossed a bright, unmistakable line that the founders carved into the Constitution. Her message is loud and clear: the federal government can't just swoop into states over local objections, especially when ordinary law enforcement is already handling disturbances. There's no open invitation in the Constitution for presidents to play military strongman on Main Street. But the ruling didn't stop there. Judge Immergut's opinion reads like a cautionary tale for all Americans worried about creeping autocracy. She writes, "This court acknowledges that some citizens may support these deployments as a helpful military supplement to effectuate the president's immigration agenda. But the founders embodied their profound fear and distrust of military power in the Constitution and its amendments, which has lived on through the decades as a traditional and strong resistance of Americans to any military intrusion into civilian affairs." In the Supreme Court's words, even slight encroachments create new boundaries from which legions of power can seek new territory to capture. The imagery here is chilling. She's not just talking about Trump, she's talking about the long-view dangers posed to liberty and democracy when Americans lose sight of the hard-won boundaries between government and military. Why does this matter beyond Oregon? Because it sets a clear judicial expectation for other cases simmering in Chicago and Los Angeles, and for every other American city that could face these tactics. Until now, courts relied on temporary fixes. Now, there's a real legal precedent. The trial held in Portland was thorough and fact-driven. Testimony showed that the area, once fraught with unrest, was largely peaceful by the time of the hearing. Judge Immergut recognized that minor clashes near a single ICE building could be addressed by regular policing, dust-ups between protesters and counter-protesters, handled as they always have been. No need for military escalation, no insurrection, or collapse of local authority. She concluded that the basic requirements, those rare, extraordinary circumstances spelled out in federal law for presidential troop deployment, were simply not met. Now, the stakes are higher as the legal battle shifts to the appeals process. The Trump administration hasn't yet announced an appeal, but history suggests it won't be long before the Justice Department tries to overturn this ruling in the Ninth Circuit. Here's where things get even more strategic. If the ruling stays at the trial court level, it only blocks Trump in this one instance, in Oregon. But if the administration appeals, and the appeals court weighs in with its own ruling on the merits, then we're talking about case law, about binding precedent that affects similar cases in other states across the entire federal circuit. The move to appeal, earned or not, risks setting a nationwide standard and creates a legal boomerang that could hit the executive branch far harder if they lose again at the appellate level. And don't think for a minute that the Supreme Court won't ultimately be involved. Trump has made a habit of pushing every defeat up the judicial ladder, sometimes counting on the court's conservative majority to hand him broader powers. But the timeline and temperature are different this time. The Supreme Court, particularly its right-wing justices, have in recent years shown little patience for lower court rulings, even those meticulously detailed over hundreds of pages. They've used what's known as the shadow docket to make sweeping, often unexplained decisions, expanding executive power or sweeping away decades of precedent with a quick unsigned order. So the million-dollar, or should I say, the democracy-defining question is, will the Supreme Court side with state rights and constitutional protections, or will it further consolidate power in the hands of the executive? Consider what's playing out across the nation. Trials in LA and Chicago are on hold as everyone waits to see if this ruling will roll like a tidal wave into their jurisdictions. The Chicago case is paused in the 7th Circuit. LA is stuck in the 9th. Advocates and critics alike are intensely watching to see whether these cases get consolidated at the Supreme Court, which would almost guarantee that one unified interpretation of federal and constitutional law comes down for everyone. If that happens, the effects ripple from coast to coast. Will cities retain the right to protect their own streets, or will they have to brace for the president's say-so on military involvement? That's the question Judge Immergut's decision puts front and center. And let's get real about the principle at stake. Judge Immergut did something even more important than call out Trump's overreach. She reminded everyone why we have these boundaries in the first place. The founders were haunted by the specter of unchecked military power. The Constitution sets deliberate limits for a reason. Power, once gained, seeks new territory. If presidents learn they can send troops wherever they please, how long until every political fight turns into a street standoff? And once that Pandora's box is open, how do you close it? That's why today's decision matters far beyond the current news cycle. It's about the pressure pushing up from below, from district judges, some appointed by past Republican presidents, against the temptation of power and the normalization of executive lawlessness. Pressure, as the old saying goes, bursts pipes. The surging expectation is now that judges, regardless of party or who appointed them, will enforce the constitutional breaks the founders intended. When people see conservative and liberal judges both drawing the line, it becomes a powerful, bipartisan expectation, a demand that law is stronger than the whims of any one leader. But here's the rub: will the Supreme Court feel that pressure? Unlike every other judge, the Supreme Court justices operate in an ethics-free zone, with no mandatory code of conduct. They can, and often do, act with impunity, erasing years of precedent if it suits their philosophy. And that has consequences, not just for the Trump administration, but for our democracy. If the Supreme Court blows past all these carefully constructed lower court opinions, it can be a single reckless decision away from unleashing executive power in ways the founders never dreamed. For those concerned about American democracy, this is the ultimate showdown. The courts are the last, and sometimes only, check left on a president intent on bending or breaking the rules. We see it again and again: presidents will test their limits, but it's up to the judiciary to push back, to enforce the Constitution's red lines. So what comes next? Appeals, absolutely. The Supreme Court will almost certainly weigh in. The political branches may try to pressure the courts, but legal arguments, and the courage of lower court judges, can still make a difference. That's why Judge Immergut's ruling feels so monumental, even as it remains bounded to the facts of Portland for now. It isn't a nationwide precedent yet, but it's both a warning shot and a legal groundbreaker. If you're watching this and wondering what you can do, the answer is be informed, be vocal, and be vigilant. Presidential overreach becomes possible when people aren't paying attention, when outrage fades to exhaustion. When judges stand up, they need public support to keep the focus on law, not power. The more people understand the real stakes, the harder it is for any administration to quietly expand its reach from the shadows. So, for those still wondering about the impact, think about the current legal climate. For years, we've heard about the danger of unchecked executive authority, the risk of a White House that sees every crisis as an excuse to centralize more power. This is about more than just Trump. It's about setting the standards for every future president, Democrat or Republican. Today, it's Trump in Portland. Tomorrow, it could be any city, any president, any political agenda. The story is far from over, and you are part of it, whether you're watching from home or marching in the streets. This is why it's so critical to subscribe, to stay up to date, because every new appeal, every new ruling, counts. These are the moments that shape not only law, but the living fabric of American democracy. Let's keep this conversation alive. What will the Supreme Court do? Will lower courts be upheld, or swept away? Can constitutional boundaries survive this era of political chaos? Should every state have the power to resist federal overreach, or will presidential authority keep expanding? Your perspective matters, and so does your voice. Comment below to join the debate, and if you value in-depth, independent legal coverage, hit subscribe and ring the bell. Share this breakdown with someone who cares about democracy and the rule of law,